Well, good afternoon, everyone, and welcome to this Francis Taylor Building Public Law webinar. The topic that we're covering today is disclosure and the duty of candour in judicial review. For those who don't know me, my name is Richard Honey. I'm a barrister at Francis Taylor Building, and I chair the Public Law Practice Group at FTB, and indeed I'm chairing this seminar. Very pleased to see that so many people have booked and logged in for the webinar today. I suspect everyone is by now very familiar with Zoom webinars and the way they work. We will, I hope, have time for questions at the end, and we'll take questions via the Q&A function on the system. You should be able to access that by clicking on the icon at the bottom of the screen. Please do feel free to type questions in as we go. We'll try to answer questions in a block at the end after the two talks, or at least as many as we've got time for. We're going to stop at 2 p.m. even if we've not got through all the questions, but if there's anything burning question that we've not been able to cover, please do feel free to email us after the webinar. We'll do our best to answer questions. All being well, the speakers are going to be able to share their screens to show some PowerPoint slides. We will email out copies of the PowerPoint slides afterwards. We are recording this webinar and planning to publish it after on the FTB YouTube channel, just to let you know. So this webinar is intended to give you an update on disclosure and the duty of candour in judicial review. It is very good timing. Coincidentally, the Civil Justice Council has only just in the last day or so published its report, which recommends changes to the judicial review pre-action protocol, including to ensure that the wording of the protocol fully reflects, they say, the requirements of the enhanced good faith obligation, including the duty of candour at the pre-action stage. So there are changes to come, it seems, there. We've got two speakers, as I say. The first, Stephanie Bruce-Smith. She's going to provide an update on recent cases on the duty of candour and disclosure in public law litigation. Those cases are going to cover issues such as the overarching principles, disclosure of ministerial submissions, relevance, privilege, redaction, the duty on claimants, and indeed the consequences for breaches of the duty of candour. And then we're going to hear from Dr. Elizabeth O'Loughlin, who will be speaking about the results of her recently published empirical study of the duty of candour, which looks at both the current operation of the duty of candour, but also how the duty might need to change in response to evolving litigation trends and indeed practices in government decision-making. So I will introduce the two speakers as they come to speak. Please do type any questions you have into the Q&A function as we go. So I will start now by introducing our first speaker, Stephanie Bruce-Smith, a member of Francis Taylor Building. Stephanie was called in 2021 and has experience of acting for and advising a range of clients, including NGOs and central and local government and other public bodies, and representing the whole range of parties in judicial review, claimants, defendants, interested parties, and indeed interveners. Stephanie's only been a tenant in chambers for a little over a year and already has appeared in the High Court alone and without a leader, as they say, in a number of judicial reviews. But I've also led Stephanie a couple of times and can attest to her excellence. I'm delighted now to be able to hand over to Stephanie.
Thank you, Richard. So as Richard said, I'm just going to give a case law update on disclosure and the duty of candour in judicial review. For this, I thought that it would be most beneficial to divide this up into a number of themes. So I'll deal with a number of cases under each heading, but the main themes being overarching principles of both duty of candour and also disclosure, and the differences between the two, redaction when that's appropriate, when that's inappropriate, the duty on claimants, ministerial submissions when they might need to be disclosed and when that might be unnecessary, and also the consequences of a breach of the duty of candour. So turning first to the first theme of overarching principles, the first case I wanted to present or discuss is Kumaravel Payanandi, and this is a decision of the Privy Council this year. And I just thought, by way of introduction, it summarizes the key principles of duty of candour, which many of you will be familiar with, and at paragraph 42, referring to both the case of Quark Fishing and the Crown against Lancashire County Council. So the first is that the respondent is under a very high duty to assist the court with the full and accurate explanations of all the facts relevant to the issue, and the issue the court must decide. And the other key principle being that there is a duty to place all cards face upwards on the table. It goes on to say that as judicial review characteristically raises questions of law against a background of agreed facts, unlike, for example, in civil litigation, disclosure is generally seen as unnecessary as a matter of English law and practice. However, where a public authority relies on a document that is significant to its decision, it's generally seen as good practice to exhibit that document as primary evidence. And it goes on to cite from Tweed and Parade's commission, saying that any summary, however well prepared or conscientiously prepared, may distort. At paragraph 44, it explains that there is a difference between duty of candour and the duty of disclosure, and that being that in the broadest sense, disclosure is often unnecessary where the duty of candour is discharged to its fullest extent. And it's worth noting that in this case, the Privy Council held that there was a duty to evidence in this case, it was in the form of a transcript of a previous hearing, in light of a conflict of evidence between witness evidence that had been produced. And because of this, it was a mere summary of that earlier hearing that was in dispute would be liable to distort rather than clarify. And for that reason, the primary source the respondent was required to disclose that in full. The second case that I think provides quite a helpful summary of what the duty of candour is about is the Court of Appeal decision in the Secretary of State and the Home Department, Secretary of State, the Home Department, and IAB. And at paragraphs 20 to 25, it discusses the nature of the duty of candour, and referring in particular to the Judicial Review Remedies and Public Law textbook that, again, many of you might be familiar with. That saying that the duty of candour is an obligation of explanation. The respondent to a judicial review claim has a duty to explain the reasoning process underlying the decision under challenge, and then explaining that explanation could be given in a witness statement or by the disclosure of relevant documents, or both, as the case may be. And finally, saying that if the respondent chooses to discharge the duty of candour by disclosure of documents, it is assumed that this is because those documents are relevant to the issues in the claim. Now, the third, maybe say, group of cases that's just relevant to have in mind in terms of considering the relevant principles for duty of candour are Coulthard and Secretary of State for the Environment. This is a decision of Mr. Justice Smith, which follows on from another High Court decision, this one of Mr. Justice Fordham in the Police Superintendent Association case, which was decided before that. In short, you have Mr. Justice Smith in the Coulthard case is responding to the decision of Mr. Justice Fordham, in which Mr. Justice Fordham set out what he considered to be 10 relevant principles for the duty of candour, and naming them in turn, for example, the standard disclosure principle being the first of these. Now, Mr. Justice Smith emphasised in Coulthard that there is only one principle governing applications for specific disclosure in judicial review claims, and this is the principle stated by the House of Lords in Tweed and Parade's commission, where Lord Bingham said that the test will always be whether, in the given case, disclosure appears to be necessary in order to resolve the matter fairly and justly. And he notes that the 10 instances listed by Mr. Justice Fordham at paragraph 15 of the police superintendent's case are a very helpful collection of examples of the application of Lord Bingham's principle, but they are not, and not intended to be, any form of codification of the law of disclosure. Turning then to redaction, the first case that I want to discuss is XY and the Secretary of State for the Home Department. In that case, the issue was whether the defendant's response to the judgment and order in a previous case, KTT, was lawful, and that case concerned the defendant's policy on discretionary leave for victims of modern slavery. In XY, the claimant argued that the defendant operated a secret policy, and that was what was being considered, and it's just important to bear in mind that context. In terms of just, there's a certain sequence of events which again is relevant to understanding the court's findings in this case, and you'll see later that I summarize that there are maybe five main findings in this case. So in terms of these background facts, in July 2023, the claimant made its first Part 18 request. That's a request for further information. And in response to that, the defendant served a partial disclosure, and that was limited to certain emails from the defendant's caseworkers containing instructions. These were heavily redacted, and no explanation was provided for those redactions. And the defendant subsequently disclosed a number of ministerial submissions, and again, these are heavily redacted so as to be largely unintelligible. And again, no explanation was provided for those redactions. The defendant later asserted that these redactions were made to protect legal professional privilege and to remove email addresses or other information that were not for entry into the public domain. Another Part 18 request pointing out that much of the disclosure was unintelligible owing to these redactions, and that the defendant had not adequately explained those redactions. They also sought an explanation for options that were provided in the ministerial submission to the minister, and these were the options for implementing that earlier KTT judgment, and these had been redacted. The defendant did provide a summary of those redacted options, these A to D, but did not, until very late in the proceedings, and not at this stage, provided the full what was actually said in those options, what was presented to the minister. The claimant then made two further Part 18 requests, again pointing out that it remained unintelligible and that the defendant refused to identify the categories of legal privilege on which it was relying. Defendant did respond to this and explain that they refused to disclose certain bits of information, including draft decisions, on the basis that these were drafts and they were not relied on by the client. And they also confirmed later that they placed reliance both on legal advice privilege and litigation privilege. So in terms of turning to the court's five main findings, this is my summary of it, they're not listed as such in the judgment. The first one is that the court found that the redaction of one of the emails, particularly the email of January 2020, was a breach. And this is very kind of sensitive to the facts of this case. And it found that redacting parts of that email, which had told officials not to serve what were called option 1 letters, so this is letters refusing discretionary leave, in order to mitigate further legal challenges, unless they were advised to do so, was a breach of the duty of candour. And this is clear in the context of this case. And you may recall I said that this was about whether or not the defendant operated a secret policy, and this being clearly relevant to that. The second main finding, and this is, I think, of more general application, was that the approach of the defendant throughout was a breach of the duty of candour. And the court described this approach as one which, at almost every stage, involved revealing as little as possible, and only then in response to specific requests from the other party. And that this was about as far from the requirement of laying one's cards face up on the table as could be imagined. And it as an example, it said that a graphic instance of this breach was the defendant's stance regarding the exact nature of options A to D in the ministerial submission, instead of taking what the court considered to be a proper approach to what constitutes legal professional privilege. The third main finding concerns what the court considered to be this proper approach to a redaction on the basis of legal professional privilege. And it said that the proper approach is redacting only that which is truly privileged, that a respondent cannot redact vast amounts of a ministerial submission on the basis that the whole of the passage had a privileged element within it. The court then turned to the question of redaction on the basis of irrelevance. And I think the full paragraph is where, or the full, I've cited in full from this paragraph, because I think it's relevant to see entirely what the court said. And they said that in the context of the duty of candour, particular care needs to be taken before material is withheld on this ground, and that unless the disclosure would be positively harmful, for example, to a third party, or would involve a wholly disproportionate amount of disclosure, material should not in general be withheld on the claimed ground of irrelevance. And again, a notable example, the court gave a notable example of the defendant's failure in this regard, which was the defendant's stance on the draft decisions, that it was not for the defendant to determine that these were irrelevant and withhold them on that basis, or at least their determination that was wrong. And the final finding relates to the benefits of a witness statement. And in this, the court referred to the decision of Mr. Justice Smith in IAB in the High Court, where he had found that reducing any explanation for redactions to a signed statement, like putting this in a signed witness statement from the person who was doing the redaction, produces decisions that are better considered. And the court found that this finding must be correct, regardless of whether this is a practice that has routinely happened, or a practice that, well, a current practice in this area. The second case that's relevant to redactions is the Court of Appeal decision in IAB. So this was appeal against Swift's decision in the High Court, where Mr. Justice Swift had held that it was impermissible for the Secretary of State, as a matter of routine, to redact the names of civil servants outside the senior civil service from documents that had been disclosed. And the appellant argument that this practice was lawful, as there was no duty to disclose irrelevant information only in order to improve intelligibility, and that even if it did, even if keeping these junior civil servants' names did improve the document's intelligibility, this could be resolved, as in the issue of intelligibility could be resolved by other means, for example, by putting a cipher in, or replacing the names with something else without actually disclosing the names. The Court of Appeal upheld the High Court decision, saying that defendants in judicial review proceedings do not fulfill their duty of candour if, save for good and specific reasons, they disclose documents with redactions of the names of civil servants. It found that there was no basis in law for redacting those names, and that the appellant, or for the appellant's submissions overall, and that the appellant's submissions were extraordinarily far-reaching. And this was particularly because junior civil servants comprise about 98% of the civil service, and it was also difficult to see why there should be a distinction between members of the senior civil service and others. And finally, the court held that redaction would result in disclosed documents that would be covered in blank spaces, and such documents were much more difficult to understand than documents which give the names of those involved. So without any ciphers in those documents, many of them, in especially email chains, might be barely intelligible, and that the process of replacing names with ciphers is often extremely laborious. Made a comment that the civil service probably has many better things to be doing than replacing them with ciphers. However, the Court of Appeal agreed with Mr. Justice Smith that it would usually be permissible to redact contact details if it is thought that that would be useful. And there may also be cases where redaction of names could be justified. And they gave 3 examples of this. For example, the first being where parts of the document were concerned with a wholly different subject matter from that an issue, reasons of national security, and also where there may be a real risk to the personal safety of the individual concerned. The Court of Appeal also approved the related paragraphs in the Judicial Review Guide, so that 15.5.1 and 15.5.3. The Court of Appeal refers to the 2023 guide, but I can confirm that the paragraphs are the same even in the 2024 guidance. So the third theme then is duty on claimants. And this was touched on briefly in the Save Stonehenge case, which was a decision of Mr. Justice Holgate, as he then was. And he held that the duty of candour applied not only to the defendants, but also to claimants, and that it is a continuing duty and includes an obligation to assess the propriety and/or viability of a claim or ground of challenge in light of the defendant's responses. The court held that this was linked to the duty to cooperate with the court. Mr. Holgate then also referred back to paragraph 15.2.4 of the Administrative Court Guide, where this is discussed, which comes to very similar conclusions and just approves that guidance. And again, the paragraphs remain the same, even though the guidance has been updated. So that brings me to the fourth theme, which is disclosure of ministerial briefings and/or the question of whether ministerial briefings are adequate. And the case that deals with this is, again, it's the same case as the Save Stonehenge case, the decision by Mr. Justice Holgate. It's just important to bear in mind the context of this case. This was in relation to a planning decision, and in planning, most decisions are taken by an inspector on behalf of the Secretary of State. And this was the context that Mr. Justice Holgate refers to this context at paragraph 154 of the judgment. But some decisions are taken by the Secretary of State, and including what are applications for what are called DCOs. So this is for larger national significant infrastructure projects, which was the case here. And that all those decisions are subject to rules, including a duty to give reasons. So in the context of this case, there would have been a recommendation by an expert panel, and then a decision by a minister whether to adopt or disagree with that recommendation. And a decision letter would have been produced by that minister. And Mrs. Justice Holgate found that ordinarily there would be no need or justification for requiring the disclosure of the briefing given to the minister who decides the matter in addition to his ultimate decision letter, and saying that the issue of whether a minister, for example, failed to take into account an obviously material consideration, or whether he failed to give adequate reasons, is determined straightforwardly by looking primarily at the decision letter and the inspector's report. So this expert report that was prepared, or in this case, it would have been a report from an examining authority. Similarly, he said that there is generally no need in planning cases for the court to be involved in what seems to be becoming a satellite ground of challenge. That is, whether a briefing, the ministerial briefing which was disclosed, whether that briefing was adequate, and whether, for example, hyperlinks that were provided to the minister provided adequate signposting as to what the minister should read. And again, he repeats that in most cases, you only need to apply the conventional principles of judicial review to the decision letter and the inspector's report. Accordingly, you continue that where the claimant makes a contested application for disclosure of a ministerial briefing, the claimant will need to explain how the particular nature of any ground of challenge for which permission is granted justifies such an order in the interests of justice. So there has been a willingness for the courts to consider the legal adequacy of a ministerial briefing, or that willingness of the courts to consider that is highly sensitive to the factual and legal context, and the court has only intervened in terms of whether the ministerial briefing is adequate in very specific circumstances. And he gives a full list of these at paragraph 158 of the judgment. I've only put two of the examples there on the slide, and just the first one being that where, for example, there's a duty on the minister to personally consider certain representations but hadn't been told anything about the subject, then a court would enter into the question of whether that ministerial briefing was adequate. And then another example being where there has been a decision to adopt policy documents, but there is no obligation to give reasons. So it's not clear on what basis that decision was made. But these are very limited circumstances. And I've just included reference to another recent case in this area where it was held that a ministerial submission or its substance should have been disclosed. So again, this choice, they're not necessarily saying in all cases you must disclose ministerial submissions, but its substance might also comply with the duty of candour. That brings me finally to the theme of the issue of consequences of breaching the duty of candour. So what happens when that hasn't been complied with? And here there's a case from the Northern Irish High Court, and this was a challenge to a decision of a council in relation to whether or not when transferring the ownership of a property, any application in respect of a HMO license by the purchaser could be treated as a new application rather than a renewal. And in that case, on the facts, the court found that the duty of candour had not been complied with. This was because there had been an affidavit sworn by the respondent saying that the council never approached a change of ownership in the same way as renewals, but that this statement was contradicted by reference to a different transaction and information that had been gathered through a FOI request. And at no time did the respondent take the opportunity to rectify the matter or provide a proper explanation to the court. The court found that this was wholly unacceptable and that in such a case, the court was at liberty to draw an adverse inference in relation to the reliability of the respondent's evidence as a whole. So that can be the consequence there of breaching the duty of candour. So that is all I plan to say about in terms of the case law update. So back to you, Richard.
Brilliant. Stephanie, thank you very much indeed. Just a reminder, if you have any questions or comments, please use the Q&A function on the system to ask them, and we'll try to pick them up at the end. So we're moving on now to our second speaker. I'm delighted to welcome Dr. Elizabeth O'Loughlin, Associate Professor in Public Law and Human Rights at Durham Law School. Elizabeth is a public lawyer who researches in the fields of comparative constitutional law and English admin law, and her work in particular uses empirical approaches to try to understand judicial review. Elizabeth has got a PhD from the University of Manchester and a Master's by Research from the European University Institute. At Durham, she teaches on public law and human rights modules across programs for both under and postgraduates. She served as the co-director of the Human Rights Centre until 2021 and was co-convener of the public law section of the Society of Legal Scholars from 2021 through to this year. So Elizabeth, I'll hand over to you.
Thank you very much for that introduction, Richard, and thank you to Stephanie for a really helpful presentation. I also wanted to thank FTB for inviting Richard for inviting me to speak today. So what I want to do is start. There we go. Start with perhaps just a little bit of an overview of the study and its motivations and its aims. So the motivation for the study came from reading submissions to the Independent Review of Administrative Law a couple of years ago. And I find the submissions to IREL really helpful. They're a really interesting snapshot of information from all sorts of different public law actors about how administrative law and public law is presently operating. And those that made submissions on the duty of candour, it's probably unsurprising, those that did commonly defended its central importance to public law litigation. And those that some remarked, those that did discuss duty of candour in their submissions, also gave suggestions, perhaps suggesting options that might aid the smoother discharging of the duty. And it seemed to me that for such a vital aspect of public law litigation, which is at the forefront of every practitioner's mind, the duty was somewhat understudied, particularly by academics. So that led me to embarking upon this project, which the central aim of which was to capture as much as I could about the operation of the duty of candour in judicial review in practice. The work, I'm very lucky to say, was supported by the Nuffield Foundation, and I set about looking at the operation of the duty in 3 ways via 3 work packages. So first, I worked with 2 excellent research associates, Gabriel Tan and Cassandra Somers-Joes, to build a data set of 322 judicial review cases mentioning the duty of candour. The data set runs to December 2023, so actually doesn't include the case law that Stephanie was discussing there, although some of that I have incorporated into the research findings more doctrinally. I followed up the case law study with a set of semi-structured interviews with 19 public law practitioners, to get a bit more of an in-depth account of practitioners' experiences with and perceptions of how the duty of candour is operating in practice. And that sample of interviewees included 3 government legal department lawyers. And the final aspect of the work was taking a diverse subset of the interview participants and conducting a focus group on potential options for reform of the duty. So the report is available via the Durham Human Rights and Public Law Centre website. There's a page for the general project, and if you navigate to that, there are also a series of other outputs that I've written that arose from the project work by myself and by other project team members. So what I intend to do with the remaining time that I've got is to give a flavour of some of the findings that I have provided in the main project report. The findings are roughly split into 3 categories or themes: the law on the duty of candour, how the duty of candour is given effect in practice, and then potential options for reform. On the law, I want to start with that question of when the duty begins to apply to parties. And the research found, and I'm sure this isn't a great surprise to many on the call, that there has been a bit of disagreement in the case law on the question of when the duty of candour begins to apply. That's perhaps best captured by 2 fairly recent cases, both of which are divisional court judgments. The 2022 case of HM against the Home Department, which stated that the Treasury Solicitor's guidance position that the duty of candour applies as soon as a department is aware of a potential judicial review challenge, accurately reflects the law, contrasted against a 2023 judgment, which is commonly referred to as the Bulb case, in which Lord Justice Singh remarked that it is usually the grant of permission which is the trigger for the duty of candour and cooperation with the court to arise. In practice, however, the duty of candour is generally treated by all parties as applying during pre-action steps taken prior to the commencement of JR proceedings to some extent. And this is partially because of that internal government guidance on discharging the duty of candour. And it's also because of other procedural rules that generally sort of mirror the duty of candour. For instance, the pre-action protocol process requiring defendants to share relevant information and documents. Not all public law practitioners that I interviewed as part of the study explicitly outlined their views on when the duty of candour potentially engages public law litigants, but those that did, there was almost unanimous an almost unanimous position that the duty of candour and cooperation applies to some extent at the pre-action stage of correspondence in advance of a judicial review claim being issued. Some focus group participants felt that it would be welcome for there to be clearer recognition that the duty of candour applies at pre-action stages of judicial review. For instance, the quote I provide here, someone remarked, I think a robust recognition that it applies at pre-action stage but that is fact sensitive depending on the context of the case. And the participant remarked that this is about making sure that the solicitor is asking those relevant questions so that anything that they assert in their response to a PAP it is correct and holds. The research therefore supports, the research therefore found, the report finds that there is some scope for the position on the operation of the duty of pre-action stage to be clarified, either in case law, perhaps in relevant procedure rules and practice directions. And with that in mind, I thought it's worth drawing attention to the recently released Phase 2 report of the Civil Justice Council review of pre-action protocols. I thank Richard for drawing my attention to this, as it was released only this month, and last time I checked it hadn't been released, but it has snuck out. And the report sets out recommendations for reform of litigation's specific PAPs, including the JR PAP, and the Judicial Review Subcommittee support the inclusion of an enhanced good faith obligation at pre-action stage, of which the duty of candour is an important aspect, as Richard remarked at the beginning of the webinar. And the Judicial Review Subcommittee recognised the judicial endorsement of the TSOL guidance on this question, in particular given by the Divisional Court in HM, and recommended that the Civil Justice Council and the Civil Procedure Rules Committee work with the Administrative Court to ensure the wording of the JR PAP reflects the requirements of the duty of candour at pre-action stage. So horizon scanning there may well be some tweaks to the JR PAP, I think. It should be noted, I think, that at the moment PAPs are still guides, but the first report of the review into pre-action protocols has recommended that they do formally become mandatory. Another aspect of the law on the duty of candour that I wanted to remark upon was the duty of candour and as it relates to unpleaded grounds of challenge. And the unpleaded grounds principle has been aptly summarised fairly recently by Mr. Justice Fordham as follows: that the duty of candour extends to documents and information that will assist the claimant's case or may give rise to further grounds of challenge which might not otherwise occur to the claimant. That the duty of candour extends to unpleaded grounds does seem fairly settled in the case law now, though just because it may, that doesn't mean, and the case law commonly make sure to make clear that doesn't mean that parties to a judicial review can fish for information more widely. The case law sometimes instead refers to or talks of the need to provide potentially relevant information. That perhaps is a bit of a different way of framing the unpleaded grounds issue. That's been my reading of it. And the information or documents provided should generally correspond to the general contours of challenge. It's not kind of an open doors invitation for a public authority to have to provide absolutely everything that might be tangentially related. There have been some suggestions, particularly, for example, it got noted in the independent review of the administrative law report, that the extension of the duty to covering unpleaded grounds of challenge might be excessively onerous for respondent public authorities. And generally speaking, my research found that this view was not shared by participants in the study, who underscored that the duty is really vital in assisting with potentially new grounds of challenge that claimants need to be made aware of, given the inequalities that do exist, inequalities of information that do exist, because it's public authorities that usually hold all of the information. It's also worth noting that participants also shed light on the fact that if you do stick too closely to the grounds of challenge as originally crafted in responses to a potential claim, that might actually encourage claimants to start throwing as many potential grounds of grounds into their letters before claim as possible at the beginning, if they are worried that approach starts to take root. So there are some decent practical reasons for the duty of candour extending to unpleaded grounds of challenge. Another aspect of the duty of candour, the law on the duty of candour, that I wanted to remark on that I think ties in quite nicely to some of the case law that Stephanie was just reporting on is the relationship between the duty of candour and the duty of disclosure. The duty of candour is consistently asserted in the case law is principally a duty of information and explanation. However, it is clear in some of the case law that it's becoming increasingly recognised that the duty of candour requires disclosure of material documents. So, for instance, in the Court of Appeal in Citizens UK noted that the duty not to mislead the court can occur by omission, for example, by the non-disclosure of a material document or failing to identify the significance of a material document. Moreover, the best evidence rule that has been developed by the courts does support provision of relevant documents, as what a witness will make of a document is frequently not what a court will make of it. Several interviewees in the study shared their view that the focus of the duty of candour should remain the provision of accurate information and explanation, with obviously relevant documents disclosed. And that's captured quite nicely by a quote I provide here. It may be that you can discharge significant parts of the duty in that classical way via a witness statement, and then it's just a question of whether you need the documents to back that up because they're obviously relevant or because they're the best evidence. I will say, though, there has, and I'm not the only commentator to remark on this, that there has nonetheless been a notable drift in judicial review in recent years. It's undoubtedly become much more document-based and much more document-heavy. And what I thought I'd do is draw upon a couple more findings now that call to attention practitioners' reported experiences of receiving disclosure of information. So I wanted to start with experiences reported about the volume of disclosure that's sometimes shared with parties. Many interviewees shared their experience of receiving what was described as an avalanche of disclosure, usually after the permission stage, and commonly without adequate accompanying explanation. I will say that's only in my reported sample, so I can't speak to how wide that practice is, but it was something that came up within my study. So looking at the quotes here, one participant noted that they had a perception that it felt like a data dump. Loads is released, but there's lots of irrelevant stuff, or they feel like they're being buried with the disclosure at certain points. And that's in spite of the fact that it has been clearly outlined in case law that public authorities shouldn't offload a huge amount of documentation on a claimant and ask them to sort of find the needle in the haystack, so to speak. Interviewees did share insights that clearly showed that there is some practice of receiving what in some instances can be fairly described as too much disclosure at points in the litigation life cycle. And many were careful to outline that this is caused or exacerbated by poor record keeping and document management systems that exist across government, where search functions for your documentation can be really challenging. They commonly produce duplicates. It's difficult to kind of produce a sensible timeline. So the report finds that resources, time constraints, and the quality of IT systems therefore place parties, particularly public authorities, in a position of really sometimes struggling to organise the disclosure in a way that appropriately accords with candour in the best way. Another aspect of experience with receiving information and documentation that I wanted to call attention to was the practice of being directed to alternate routes of information. So several practitioners reported that it was common for them to be redirected to alternate avenues for securing information in correspondence, such as by submitting a Freedom of Information request or a subject access request, particularly at pre-action stage. And participants highlighted the practical challenges they felt they faced if that did happen, particularly because of the implications it might have for kind of responding to or bringing your judicial review proceedings promptly. The one participant said it isn't really an answer because of the requirement to act promptly in JR proceedings. The delay of the timings for getting the information via, for example, the FOI route are such that it means they feel like they've not got the information to then promptly respond and issue if they think they need to issue. And one remarked that often their cases are urgent, so it just means that it becomes quite a difficult route of information for them. The research therefore found that there is some evidence of public authorities directing claimants to seek information via alternate routes, rather than providing the information as part of their duty of candour. And that route has the potential to frustrate claimants' capacity to bring a claim promptly and to narrow their grounds of challenge. Just a short remark on enforcement. I am close to wrapping up now. Most interviewees thought the court's approach to moderating and enforcing enforcing consequences for non-compliance with the duty of candour was really quite appropriately balanced. There was a sense that courts, and you see this in the case law as well, are very aware that questions of the failure or of breach of the duty of candour really attach to and bite on the professional duties of the legal professionals involved, and the courts show a sensitive awareness of that. They commonly acknowledge where they can see that an issue with compliance with the duty has arisen in spite of a legal professional's absolute best efforts. That being said, some interview participants did note that they felt there was scope for courts to perhaps get a little bit more stuck in on the duty. Some remarked that this might be perhaps a sort of flagging that maybe a case management conference might be required to hash things out, or kind of ideas like that arose amongst participants. I want to finish by talking about the recommendations that the report makes for reform. The focus group that I conducted discussed an array of reform options. Amongst the focus group participants, but also amongst the interview participants, it became quite clear to me that there is a clear appetite for some formal recognition of the duty, some more formal recognition of the duty in the civil procedure rules in some form. And I took the view and recommended that the Civil Justice Council should consider the formation of a working group to test and consult upon proposals for the development and incorporation of guidance on discharging the duty of candour into the CPR. Participants showed an interest in recognition of, or more guidance on, for example, clarification on what stage of proceedings the duty is engaged, maybe more guidance on the format of disclosure. That could be redactions, sort of bringing to attention some of Stephanie's remarks. It could also be approaches to sort of gisting or quoting from documents, others remarked it might be helpful for there to be an outline of potential consequences for non-compliance or breaches with the duty in the rules more formally, subject to that retention of a residual judicial discretion for courts to be able to utilise their case management powers as required. The most compelling reason I thought that participants gave for the strength of perhaps putting the duty of candour on a firmer CPR footing was that it was felt that this would aid practitioners in their work with their clients. It was felt that pointing to a client to a clear rule was felt to perhaps be more persuasive or clearer than pointing to various guides or case law in being able to explain and help the client understand the importance of providing information and also providing information in a correct and helpful format. I will conclude there. Thank you very much. Let me stop sharing.
Brilliant, Elizabeth. Thank you very much indeed. And just a final reminder to attendees, if you've got any questions or comments, please use the Q&A function to ask them. So we've got a few questions. Stephanie, I was going to ask you to take the question where there's an example of a campaign group where it said they're unlikely to have standing, but they want disclosure of documents and commence judicial review through a pre-action letter and then to the permission stage to try and get hold of the documents. And the question is, would a defendant be at risk of criticism or sanction if they refuse to provide documents to a claimant who would not have standing at the pre-action and pre-permission stages?
Okay, yeah. So I think the first point that occurs is it's quite rare in judicial review proceedings for claimant groups not to be afforded standing. And I'm sure participants will be aware that there are some instances, some kind of narrow examples where that has been found. So that would just be the first case, just to be cautious about taking approach, like just make sure it's definitely the case they are unlikely to have standing. But I guess I would think that if it was highly likely they wouldn't have standing, I think stating that you'd only provide very limited disclosure at say pre-action stage or permission stage on the basis that they don't have standing is unlikely. I mean, probably unlikely to be something the court would say doesn't fall within the would breach the duty of candour, particularly if then the court went on to find at permission stage that the claimant group didn't have standing. So I think you could probably justify limited disclosure at that stage, but you'd have to be pretty sure that this claimant group wouldn't have standing at all. I think that would be my view. I mean, do you have anything, Richard, that comes to you? Or
no, even... I think that's right. I could see Elizabeth was nodding. Was there anything, Elizabeth, you wanted to add to that?
Sorry, I'm just rereading the question.
Yeah.
Persistent action if maintains a refusal to. I think, yeah, I mean, my sense would be, yeah, that there seems to be sensible grounds for providing limited disclosure and discharging the duty by way of sufficient explanation at that stage. Yeah.
Yeah, great. And I had a question that I wanted to put to you, Elizabeth, arising out of linked to that on pre-action duty of candour. You referred to the HM case and the I think both that and the CJC report refer back to the TSOL guidance on the duty of candour applying at the pre-action stage. Now, that guidance, of course, is not law, and there is some other case law, I think, for example, pointing the other way. And I was just wondering, given that guidance is what now, 14 years old, I think it was 2010, what you thought would happen in practice if the TSOL guidance changed to remove the acceptance of the application of the duty of candour at the pre-action stage, or perhaps to qualify it in some way about the intensity of its application at the pre-action stage, or even just at pragmatic points in relation to the ability to meet the duty of candour at the pre-action stage, given the timings. Do you think it's too late, essentially, for the TSOL guidance to row back from what it said?
Yeah, in a way, I think it probably is. But at the same time, I've always felt that TSOL guidance position actually accurately reflects what happens in practice anyway. And then it's a semantics, whether you frame that as the duty of candour or just cooperation more generally, right? So, I mean, my sense is that if you're really taking kind of pre-action correspondence seriously, you're considering that overriding objective, you're thinking about it being a duty of candour and cooperation. That mirrors you thinking in terms of the duty of candour, which is, I need to provide enough information here so that they can accurately reflect upon, do I have a solid grounds to issue here? But it's also, which was something that was in one of the quotations from a participant on my slide, it's also about making sure that the response put forward by the public authority is sufficiently robust at pre-action stage, and that does engage that checking that is a duty of candour activity, really.
Yes.
So I don't know whether it would result in that much practical change. It may help a little bit with resisting, I suppose, disclosure of documents pre-action, but I mean, that's context sensitive already anyway.
Yes, I think in my experience, at least, central government does comply with the TSOL guidance. Local authorities not bound by that guidance as such. So maybe, as you were recommending, some further clarification would help. Linked to that, we've got a question about the consequences for the breach of duty of candour, where the question is, are there other consequences beyond judicial criticism or adverse inference? And whether there was any precedent, for example, for finding of contempt of court. Stephanie, if I come to you first, what is your thinking on consequences for breach of duty of candour?
Yeah, no, I think that the question, as the question says, the main consequences would be judicial criticism and adverse inference regarding the evidence as a whole. I don't think, I don't know of any precedent for a breach leading to a finding of contempt. I would think that this would be a case where, if anything, the Hamid jurisdiction would come in, which is the jurisdiction of the court to govern its own processes. So you could have the lawyers being summoned before the court to explain why they haven't complied with the duty of candour, and that would be a sufficient deterrent in most cases. I guess also, I mean, especially if, for example, you had a case where a legal representative advised the disclosure of certain information, the client refused to comply with it under the lawyer's own professional duties, they would, in that case, may be obliged to withdraw from the case and not act as they'd be professionally embarrassed in that case. So that would also be another potential consequence. But yeah, no, I definitely don't know of any precedent for finding of contempt.
Yeah, I think it's been referred to before as a self-policing duty, and in truth, I think it is the lawyers that police it. Liz, what do you say about enforcing the duty of candour and consequences for breach?
Yeah, so there is a sort of list of, I drew up a list of potential consequences based in part on kind of your resources like the TSOL guidance, but also in part from case law. And it was, you know, primarily adverse inferences, adverse costs ordered, so it can sound in costs if you've got issues of candour arising in the cycle of the case. A formal order of disclosure is sometimes seen as a sort of adverse consequence. Of course, that's not always kind of the reality of the disclosure order. It doesn't mean that there's been a duty of candour breach, but it is sometimes floated as a potential consequence. Reputational damage, and if you another consequence that gets listed is materials subsequently produced that may not be relied upon without permission of the court. So that idea that if you come to the court with something quite late, you do need to sort of ask for permission to be able to rely upon that. And then referral of practitioners to the appropriate professional body, which, as Stephanie noted, you'd be talking about the Hamid jurisdiction there. In my case law data set, I had 2 referrals of practitioners to appropriate professional bodies, but I never saw anything amounting to contempt, although I'd have to remind myself and go back. I think it did get floated as an option, not for the particular practitioners, but just noting that it could go that far. And both of those cases in my data set were claimant solicitors.
Yeah, great, thank you. So there's a question about whether a failure of a respondent to a pre-action letter to provide information and disclosure would be an excuse for delay in commencing a judicial review. My immediate response to that is it would be very, very risky to try to take that approach, and that you are far better off commencing proceedings in time and then seeking the disclosure of the information if necessary at the pre-permission stage, rather than trying to rely on the failure of pre-action disclosure to excuse delay. I can see both Elizabeth and Stephanie are nodding. If you've got anything to add, please do jump in, but maybe that's straightforward enough.
Yeah, I think so.
Okay.
Sorry, just to highlight that I think this is what annoyed Lord Justice Singh in the Bulb litigation. So that might be helpful kind of looking at it. It wasn't a delay. It was sort of felt that a dispute over pre-action disclosure was delaying the proceedings. And it was, I think, an irritant for him. So that might be worth taking a look at.
Yeah. Okay, great. So there's just one further thing I wanted to raise for both of you just to reflect on the future, because I mean, Elizabeth, it was very interesting with your thinking about reforms, generally speaking, I mean, partly adding clarity, but also perhaps towards increasing the burden of the duty of candour and disclosure. And with Stephanie's case law update, maybe a mixed picture from the cases, some pushing for increasing transparency, some against. Now we've got a new government. It is consulting, for example, currently on reform of judicial review for nationally significant infrastructure projects. That doesn't, I think, cover the duty of candour, but I'm interested to see whether you think there's any prospect of any pushback from the government against expansion of the duty of candour in the future, particularly perhaps in the field of planning and infrastructure judicial reviews, where the government is very keen to push on. And you can see areas that are difficult, such as maybe the pre-action disclosure or unpleaded grounds, or the actual disclosure of documents being areas where the government might wish to push back. So I just wonder whether you've got any thoughts on that. Maybe Elizabeth first.
Thank you. Yeah, that's a really good question. So what's interesting, I think, about that consultation exercise on the basis of the Banner report into nationally significant infrastructure projects is that the consultation exercise also does have a rather open-ended component at the end about sort of anything else, any other judicial review reforms that you think might kind of aid the smoother kind of process, smooth out the process a little. So I think it's just worth noting that there is something a bit broader there as well in that consultation. Pushback. So one thing that I should stress about my findings, and one of the reasons my findings are a little cautious on the point of reform, which is sort of kick this a bit more to a more formal process led by the Civil Justice Council, is recognizing that I could only interview 19 practitioners, so I won't have a much wider account of how people feel about this. But generally speaking, my information that I gathered was a sense that parties don't want the duty, or participants don't want the duty to be extended necessarily. They're kind of happy with there being a statement that accurately reflects how it's already operating, or how the statement of how the law as it already is. And it is highly context sensitive, which means there will be cases like Stonehenge, for example, that Stephanie was talking about, where actually, you know, in particular contexts, it may not be worthwhile having an absolute kind of fight about a particular ministerial briefing. And the judges are likely to try and police making sure that those arguments don't get out of hand. So does that answer your question? I don't know whether it does. I
think that's
because I don't know whether anyone's suggesting that it be extended.
Yeah, no, I think that's a very good answer, and indeed a good note to end on, Elizabeth. Thank you very much indeed. So I'll draw it to a close and just say thank you again to Elizabeth and Stephanie for their talks and indeed grappling with the questions as well. And just say in closing, we are going to be running some further public law webinars next year. I think we've got 3 planned for the first half of next year. On the 29th of January, we'll be doing one on alternative dispute resolution in judicial review, which is another subject that comes up in the Civil Justice Council pre-action protocols report. Then on the 26th of March, one on an update on retained EU law. The 4th of June, we'll be doing a judicial review costs and procedure update. So hopefully you'll be able to join us for those webinars as well. Thank you ever so much indeed, everyone, for attending.